All right, well, welcome to the third talk in our webinar series. This is the second civil talk. For anybody who missed the first, we were talking on Monday about limitation periods and applications for relief from sanctions. The recording of that, the note and the slides are all up on our website, and throughout this we'll refer to one or two other notes that we've done as well. But today, we're going to be talking about commercial tenancies and the impact of COVID-19, an awful lot of it surrounding payment of rent, what happens if you don't, and considerations if you don't, delivered by me, Oliver Newman, and Ian Cain joining me. We're just going to start off with, though we've dealt with it elsewhere, but we're going to start off just talking about Practice Direction 51Z. So Ian, if you can just talk us through the practice direction.
Certainly. So CPR Practice Direction 51Z now means that all proceedings to enforce an order for possession by a warrant or a writ of possession are stayed for 90 days. And that's from the 27th of March 2020. So this is applicable not only to residential lease, to commercial leases, but also to residential leases. And I will use this opportunity to advertise the fact that we do have another presentation dealing specifically with residential leases. Now, Civil Procedural Practice Direction 51Z was amended by Practice Direction 51ZA, which created an exception for an application for agreed case management directions. That was imposed in order to allow parties to get ready for the lifting of any stay, and mean that cases weren't necessarily going to get stuck in the mud and some progression could be made on them. I'd like to note at this point that if you go to the news section of the Chamber's website, you will find a practice note, which has already been uploaded, which considers the effect not only of Practice Direction 51Z and 51ZA, but also Practice Direction 51Y. Now, I suppose, Ollie, the question is, have we actually seen CPR 51Z being tested within the courts in any way?
Yes, Ian, and frankly, that's why we're talking about this in this webinar. It's obviously something we've touched on elsewhere. But judgment came out on the 11th of May, so a few days ago, in Arkin and Marshall, and the citations at the top, where the validity of Practice Direction 51Z and 51ZA and a couple of other points were considered by the Court of Appeal in a fast-track appeal. Key points that have come out of the case are, perhaps unsurprisingly, both practice directions were not made ultra vires and should be followed, but 2 points that are perhaps a little bit more interesting. Firstly, the court does have a discretionary power to lift the stay, and because it's a practice direction, it does not have to be slavishly followed. The court does have discretion. However, the Court of Appeal made very clear that the reality is that that power is expected to be largely theoretical. They don't really anticipate the courts ever using it. They did say it was possible, but couldn't really think of a clear example when it might be appropriate. The only exceptional sort of guidance or idea they gave was that the point underlying the practice directions were the protection of public health. And if you did have a possession case where the failure to determine the proceedings and potentially make the possession order might itself endanger public health, that could be grounds in a circumstance where it would be appropriate to lift the stay, but those would be vanishingly small circumstances. So there is a discretion, but not really, unless you somehow have a very unusual case. The second point they made, which may well be of some use, is they emphasise that parties under Practice Direction 51ZA2A, parties can make an application for case management directions which include dates within the stay period. So if you have a case where both parties are keen to get it moving and to minimise delay, you can write to the court and ask for dates to be fixed for the exchange of witness statements or disclosure or the like within the stay period. The impact of them being within the stay period means they can't be enforced during the currency in that period. So you can't make an application to the court for failure to follow them or for relief from sanctions or anything of the like. So that is a way of progressing your case, allowing the litigation to turn over, even during the stay period. But of course, the limitation is it does have to be agreed directions. Both parties have to agree to try and progress the case. So in terms of memorandum on forfeiture, which is perhaps the big thing that everybody's aware of.
Indeed. So as you can see on the slide, Section 82 of the Coronavirus Act 2020 introduced a temporary moratorium on the forfeiture of commercial leases for the non-payment of rent during the relevant period. Now, it's important to note at this stage that that is only in regards to the non-payment of rent. And that runs up until the 30th of June 2020, unless, of course, the government decides to extend those provisions. The problem with Section 82 of the Coronavirus Act 2020 is that it now applies retrospectively, proceedings that were meant before the legislation was passed, but an order was not made. And orders now made must ensure that possession does not have to be given up before the end of the relevant period. So it's almost a bit of a catch-22 situation there, where you now can't apply for forfeiture of commercial leases, and possession can't be given up until the 30th of June 2020. I suppose the key points to take away from the legislation is that the legislation has a particularly wide scope. It's important to note that this only relates in regards to the non-payment of rent, and rent is being defined as including some that a tenant is liable to pay under a relevant business tenancy. As such, it does mean that it is going to include things like service charges and insurance payments. Could potentially include payments for breaching a repairing covenant. The protection does not distinguish between those unable to pay as a result of the coronavirus and those that may be unable to pay due to other financial reasons. The legislation has a narrow scope, however, in other respects, in that it only applies to failures to pay and does not prevent forfeiture proceedings being started on any other ground. When it comes to the non-payment of rent, it is important to note that it is not a rent holiday, and that rent from tenant in commercial leases will still remain due. Rent and other monies, therefore, will continue to accrue interest, which does mean that tenants in commercial leases may well end up with quite a substantial sum that would need to be paid at the end of the period, currently up to the 30th of June. No contact by the landlord, short of express or waiver in writing, will be regarded as waiving the right of re-entry or forfeiture for non-payment of rent. Now, this is particularly important because as a landlord in a commercial lease, it is therefore up to you as to whether you agree with your tenants under the commercial lease to accept a percentage or part payment of the rent which is due, and you still have the right to claim the full rent sum after the 30th of June 2020. So given that this moratorium is now in place for forfeiture, are there any other alternative approaches that can ultimately be taken in order to try and enforce?
Well, yes. Just to note, I saw a hand up earlier. Because we've got quite a lot to get through, we're just going to run through it. But please, if anybody does have a question, please feel free to ideally put it in the Q&A section, but otherwise put it into the chat. And when we get to the end, Ian will run through them and we'll do our best to answer them when we get there. But because of the moratorium on forfeiture, emphasis has been shifted to alternative methods of enforcement where you've got a debt created by non-payment of rent. On the 23rd of April 2020, the government announced proposals to limit the use of such methods. So the use of statutory demands will be banned between the 1st of March 2020 and the 30th of June 2020. And the suggestion is the winding up petitions will not be able to be presented between the 27th of April 2020 and the 30th of June 2020. One point to note, and I'll come back to it in a moment, is that only where a company cannot pay, this is only impact, the proposal is for this to only be where a company cannot pay its bills due to coronavirus. And I should note that these parts that I've mentioned there, the proposals, are yet to be turned into legislation, so we haven't seen the final form. But from the proposals that we've seen, there are a few key points arising. It appears the enabling legislation for these changes will be narrower than the moratorium on forfeiture. in that the suggestion is they'll be limited to cases of non-payment due to coronavirus. But having said that, for anybody that's sort of looking, well, oh, hang on, I can get round that, we can argue this. Although it may be narrower, it's likely there'll be practical problems in trying to take advantage of that. We don't yet know the mechanism, that's going to be decided, but it's likely it'll require cases to be listed and evidence heard in order to determine the cause of the inability to pay. And frankly, given the way that courts are listing cases at the moment and the backlog, any hearing that is going to require substantial evidence to be heard, it's more likely that the relevant periods will expire than the court will determine this issue in a point in time to be useful. So although it's going to be narrower, the actual help in that narrowness is unlikely to emerge. Other key point to note, and these proposals do not affect the ability to sue a guarantor if sums due are not paid, nor to withdraw sums held on rent deposit in accordance with the terms of the lease. So be aware that you can go back to the lease, think about some of the ways of enforcement that may be embedded in the lease in terms of guarantor, the terms upon which deposits held. A landlord may be able to withdraw money in the deposit, or may be able to sue for the rent in a different way. Where the government's proposals have indeed been turned into legislation is in amending the commercial rent arrears recovery rules. So these were part of the proposals back on the 23rd of April. This has now been turned into legislation. I haven't put a note in there, but it is in the note as to exactly which the regulations are. But landlords are now prevented from using the procedure unless they're owed 90 days of unpaid rent. Obvious point to note that this extension is not really going to help those paying rent quarterly. If they miss a rent payment, then they will owe 90 days of rent, and so that's not really going to assist you. Some of the timings around the enforcement and so forth that have been extended, and enforcement agents are prevented from taking control of goods at residential premises or on highways while the lockdown restrictions are in place. So you can't take cars and so forth. Wider considerations with non-payments, to come back to sort of where we started here, that although you may well, tenant may well take the view that, well, because I can't be evicted and because there's protections against non-payment of rent during this period, should we simply stop paying? Are there any real downsides? Well, we've already mentioned the issue that debt is likely to accrue interest depending on the terms within the lease itself. But there are a couple of other things to think about. Firstly, are there any considerations or side agreements in place? Such agreements for reduced rent or turnover only rent are often predicated on the continuing payment of that rent as agreed. If you default, that could mean reverting back to the rent as set out in the lease itself, and thereby a considerable rent hike. So be very careful if you've got such side agreements in place, because you seriously disadvantage yourself by not paying. Secondly, is the tenant looking at exercising a break clause? Break clauses often require all rents to be up to date as of the date of exercising the break. So if you've got rent outstanding, you're not paying your rent, then landlords may simply be able to disregard the break clause and say it's of no effect, and therefore you've got to keep paying. So be aware that there can be some wider considerations to non-payment of rent that might affect your position going forward, even with the protection against forfeiture. So where does this take us really? If we've got protection from forfeiture, but what if I'm still not in a position to pay my rent? What as a tenant might I be able to do?
Well, ultimately, the first step for you is going to be to take a look at your commercial lease agreement itself, and in particular, pay attention as to whether there are any clauses dealing with force majeure. Now, it's understandable that prior to the current pandemic, very few commercial lease agreements contained any form of provision in regards to force majeure. Even rarer was any form of provision dealing specifically with pandemics, such as the current COVID-19 pandemic. Now, this therefore raises the question of that if you have a tenant of a commercial lease and their business is shut down as a result of the current pandemic, can that tenant rely on frustration in order to avoid having to pay their rent going forwards? Well, unfortunately, in short, the answer is that it's unlikely. However, there are potentially situations where it could be arguable. So let's go right the way back to basics and remind ourselves of the test for frustration. Now, the test to establish whether a contract is frustrated is a very high one, and it can ultimately be summarized by three individual stages. The first being performance of a contractual obligation must be rendered impossible, or the operation radically different to what was envisioned at the time that the contract itself was formed, due to some form of unforeseen or supervening event. The second is that the supervening act cannot be caused or due to either of the two parties to the commercial lease. And the third is that the contract must not provide an appropriate force majeure clause or provide for the allocation of risk arising in the event of a pandemic. So effectively, neither party must have been able to foresee that this was an issue that was likely to arise during the course of the commercial lease. So now that we know what the test for frustration is, the key question is, how is this actually going to play out in the courts? And have there been any examples of this?
Thank you. And I should just stop here to note that myself, Ian and Daniel Searle, another barrister in Chambers, have written a note on frustration, force majeure clauses and supervening illegality, just dealing with these issues, not necessarily specific to commercial leases. But if anybody is after a primer on all of this, that equally could be found, that note could be found on our website. But the answer is yes, courts have looked at frustration in the context of commercial leases relatively recently in the high profile case of Canary Wharf and EMA. That, of course, was in the context of Brexit and was only in the High Court. It didn't go up to the Court of Appeal. There was talk of it being appealed, but in fact the case settled in the end. So it's only a Court of Appeal authority, but it's still a reasonably clearly thoroughly argued issue, a case on frustration on a, in some ways, a relatively similar topic. Now, I've set out in the note that will provide some more detail on the judgment, but to take away some key points from it. Firstly, the fact the tenant couldn't use the premises for its intended purpose did not mean the lease had no value, and consideration should be given to trading in a different way or subletting. So in this case, EMA was intending to use the premises as its headquarters in the UK. Because of Brexit and the rules around the EU, it could no longer do that. So their argument was essentially that they didn't have any value, and to them the whole thing was frustrated. They couldn't use it, completely against the intended purpose. And the High Court said no. The fact that you couldn't perhaps use it as you wished to did not in and of itself mean it had no value. Other people could have, you could have sublet it to others, you could have had an income from that. So said no, that wasn't enough. Note that if a business could have continued to trade in some form and did not, this is likely to be regarded as self-induced frustration. So here, although the EMA perhaps couldn't have put their headquarters there, they could have used it as office space or the like. Perhaps in more detail for this, that if you've got a situation where, so you've got a retail shop and you're one of the retail shops that is not really supposed to open at the moment, question is, could you trade from the shop in some form? Could you use it as your packing location or the location to run an online business, something like that? Equally, I think something to be very careful of at the moment. The legislation that's been passed is quite wide in terms of preventing shops opening, but it doesn't cover everybody. Quite a few, for example, builders merchants that were allowed to trade shut down for a period of time. If you're not trading, not because you can't, but because you've chosen not to, we've got arguments about whether you could properly social distance or the like. Here, I think there's a real risk that what the court's going to say is this is self-induced frustration. You're really going to be looking at areas where you simply can do nothing with that property. Break clauses were something that the court looked at in quite some detail in Canary Wharf and form part of the judgment, but they're likely to be seen as an indication of how the parties allocated risk. What I mean by that is if you've got a break clause that operates quite towards the beginning or early on in the lease period, and you can exercise it after that. So you've got a fairly tenant happy break clause. That is likely to be seen as the fact that the landlord is taking more of the risk of something going wrong and the tenant taking less. And of course, there's a bit of a catch-22 here in that if you've got a very friendly break clause as the tenant, you may well want to simply rely on that rather than trying to run frustration. If you don't have a break clause, it is probable that the court will look at that as the fact that you, as the tenant, were allocating or taking the risk as part of the contract. Simply in the point made in Canary Wharf that it is always possible that a business will need to move premises. It loses some space, it loses some work and needs to downsize. It gets too big, it needs to upsize. Their decision to move, the premises for some reason are no longer suitable. And so there's always going to be a risk that a business will not actually want to keep a property for the full length of the existing lease. And the break clause is going to be seen as an indicator of how the parties allocated that risk. So if you've got a break clause that isn't helping you at this point, it may well be seen as the fact that the court may well see that as the fact of, well, you've accepted that risk when you signed this contract. That's how the parties allocated the risk. And indeed, the Court of Appeal said that the fact that you might choose to activate your break clause versus being forced into a situation like that might be produced by COVID was not a substantial difference, really. The question is, how was the risk allocated? How easily could you have got out of your obligations? And if the answer is you got into this knowing you would struggle to get out of your obligations, that's going to be an indication as to allocation of risk that isn't going to help you necessarily with frustration. Lastly, it's likely to be an uphill battle to convince a court of common purpose going beyond the terms of the lease. So EMA sought to argue, based on the fact that in the premises in question that various changes have been made at their request, to say that it was part of the common purpose of the contract that they would occupy it as their headquarters. Now, the Court of Appeal said no, they wouldn't read something as wide as that common purpose into the lease. It said, well, the purpose of it was for you to rent the premises from them and to use it as is set out in the lease. The lease didn't say within it, this is to be your headquarters for now and forever going forward. So you've got to be aware that the court is not going to easily read in a common purpose beyond the terms of the lease. Again, all of this is likely not to help your frustration argument. So we mentioned at the start that perhaps there could be a persuasive case for frustration. Well, firstly, where the period of occupation is likely relatively temporary in comparison to the term of the lease, that's not likely to help you. Of course, the opposite is also true. If you've got a lease for a limited period remaining or a limited period full stop, you are more likely to essentially have lost the entire benefit. If you've got a lease that's 6 years long and you're not able to use your premises for 3 months due to COVID, then you're unlikely to succeed in arguing frustration. There's enough of the lease there, both before and potentially after, for it to still have significant value such that it's not frustrated. But if your lease is 6 months long and you're 2 months in and you then can't use your premises any longer, then you've got a much better argument for frustration because you're not going to get it back, you're not going to be able to use it. So if a lease has got a limited period remaining, that's the start really of what's likely to be your best case of frustration. One point to note, however, is that of course the shorter your lease is, the more likely you're going to have arguments about foreseeability. Did you sign this knowing it was possible that COVID was coming and that there would have to be a shutdown for a period? So dates are going to be important there, probably matched against what was happening in Italy and how much that was being covered. So secondly then, where user provisions are restrictive such as to prevent or limit the ability to pivot usage, you're more likely to have frustration found. So, as I was saying earlier, if you've got very restrictive usage provisions within your lease, then your ability to shift to using it as a delivery location for an online offering or something like that, that restriction means you're more likely to be able to argue that you can't take any value out of your premises that you've got, and therefore more likely that frustration will be found. If there is flex such that you could use it in a different way, then you're going to struggle in terms of frustration. Similarly, user provisions which restrict the ability to assign or sublet the balance of the lease to a business that would be able to make use of it, that's also going to bolster your case of frustration. If the terms of the lease are such that you can't assign or sublet it, then it doesn't have so much value because it's only got value to you. You can't use it as a way to obtain income by subletting it. And if you can't use it for your intended purpose, and equally you can't pivot it to do something slightly different with it, then that's where you're going to have your best case of frustration. The only other point to make is that even if you do have a situation where you've got the ability to assign or sublet the balance of the lease, if you can argue that market demand is such to make that ability to assign or sublet effectively worthless or pointless, and that also is going to go towards arguing that you no longer have any value in your lease and that it is therefore frustrated. So, is frustration going to be an easy get out for tenants? The answer straightforwardly is no. There is a narrow set of circumstances where frustration may work. I'm not aware, and I don't think there are any reported cases where frustration has successfully voided leases, but there is potentially a narrow window in which it may be arguable. So it's worth keeping an eye out for those sorts of situations where clients approach you. But perhaps to try and pull this all together, what does this legislation do? In short, really, it gives tenants time, a time when you don't have to pay. It, however, does not remove the requirement to pay. It does not prevent interest being accrued. It doesn't prevent some other ways of enforcement. What's being bought is time. Now, that means, of course, that there is going to become a point when this time runs out. So from the point of view of tenants, you need to be very careful. This is not giving you a rent holiday. Your obligations to pay rent still remain, but it just means that you've bought yourself a little bit of time. But you're unable, it's very unlikely you're going to be able to escape those obligations through frustration. Equally from landlords, though, you're going to have to sit and wait and accept that some of your tenants may well be accruing debts. There is going to become a period where these limitations come off and you're still going to be owed all that money. That debt isn't going anywhere. So what it really comes down to is that during this period, although the law is providing time, it's not necessarily providing a lot of solutions. So realistically, early commercial engagement between landlords and tenants is going to have to be the watchword for the next little while. You're far better, both landlord and tenant side at the moment, to get better arguments better outcomes by negotiation than to push for sort of hard solutions either side, either frustration from the tenant point of view or for forfeiture or the like from the landlord point of view. I hope that's been useful. I can see we've got a couple of questions popping up.
Indeed. So starting off with the first question that we've received in regards to rent negotiations with commercial landlords and whether we believe that it would be worth entering into rent negotiations with a commercial landlord if you're a commercial tenant. Well, ultimately, my answer to that would be yes, certainly, but it completely depends on the particular circumstances of the case. As we discussed earlier in regards to the moratorium on forfeiture, you can reach agreement with your commercial tenant for the part payment of rent, with the whole of the rest of the sum of rent for that period being due once the restrictions are lifted. If you make any form of agreement with your tenant, you will have to make it very clear that the outstanding rent will eventually have to be paid, and it is not a rent holiday overall. I see that we've got another question, and I should highlight that all questions will be asked anonymously. Moving away from leases, but commercial contracts, would frustration be a viable argument in cases where COVID has obviously been the supervening act, which has meant that the contract cannot be performed? Now, this question perfectly sets up the practice note that we have on the new section of our website dealing with force majeure, supervening illegality, and frustration. If you have a look at that practice note that we've created, you'll see that it's in relation to all contracts, not just specifically commercial leases like we have done for the purposes of this presentation here. Ollie, do you have anything to add on that?
I think it's really, I mean, without more details, it's difficult to say, but I would, you've got a series of things to look at. Firstly, you've got to look at the contract itself very carefully. How does the contract allocate risk? Is there a force majeure clause that you could use that says, in the circumstances of something along the lines of COVID, this is how the losses will fall? Presuming that's not there, and for an awful lot of contracts it won't be, you've then got questions of supervening illegality and frustration. Supervening illegality is simpler to argue, but requires you to look very carefully at the legislation. As I flagged earlier, there is a big difference between what essentially is being announced by ministers and what is actually the law. And so you've got situations where people might decide to do something on the basis of what's being indicated as good practice. That does not necessarily mean that supervening illegality is going to come to your rescue. Frustration then is really the last gasp. It's difficult to make out, but there are undoubtedly going to be cases coming along where frustration is going to be made out. There's no question of that. Some of the more obvious ones are going to be things like pubs, but they may well be dealt with under illegality anyway. It's going to be important to run through those, be aware that exactly how the losses lie may vary depending on where you end up with them, because illegality and frustration can end up with different allocations as to where the loss falls. But it's working through the three options really, and giving it some thought. As I say, I think we're likely to have some leading cases that'll come in a few months' time. Probably there'll be some accelerated cases and accelerated appeals that'll lay down some better guidance on frustration and COVID. And once those come through, we'll have a much better idea of how the court's going to deal with specific scenarios. So work it through, terms of the contract, exactly what is currently legal and illegal in relation to the business. If none of that's going to help you very much, frustration is the next stop. It's going to work sometimes, sometimes not. It's a narrow doctrine, but it's built for this kind of scenario that we find ourselves in. Until we get a bit more guidance, what's set out in Canary Wharf is probably the best that we've got at the moment, certainly in relation to commercial contracts.
Sadly, I note from the time that we've already gone well past the half an hour that we have scheduled for these webinar sessions. Therefore, if I could just highlight to everyone that tomorrow we have the first talk being given by the immigration team on long residence under paragraph 276. A and B of the rules post Ahmad. And the next civil team webinar will be COVID-19 and possession proceedings in residential leases on the 19th of May. Both of those webinar sessions, and indeed all of our webinar sessions, will be at 3 o'clock each day. If I could also just remind you that this webinar session will be going up both on the Chambers website in the news section and also onto the new Goldsmith Chambers YouTube account as well, so you'll be able to find the videos on there. If you have any further questions, and we unfortunately have run out of time and couldn't get to your questions, please do get in contact with the civil team clerk on the information which is outlined on that slide. And thank you ever so much, everyone, for joining us for today's webinar.
Thanks very much, and have a good afternoon.